Members, we're formal quorum. I call the meeting to order. Please invite the government officials to join us. While they are being seated, may I remind members that if you have to make any declaration, please do so. I'll do it myself. The group I work for has got the investment in hotels. Please ask the officials to join us. Welcome, government officials, for your attendance. We have had a number of meetings with the group of officials already, so I won't introduce them one by one. Who would walk us through the paper first? Under Secretary. I'd like to thank members for their suggestions in the past 3 meetings of the Bills Committee. They have made very useful suggestions on policies. Last time we proceeded to the cross examination, and we have completed part 2, cross 11, part of cross 11. Before we proceed further, I would like to introduce the major contents of the remaining clauses. For part 2, the remaining parts of part 2, there are amendments to the principal ordinance, including the provisions for the improved licensing system. The authority will be authorized to consider whether the deed of mutual covenant or the land lease has some restrictive clauses on this trade, and also the views of the local people. And we have also increased the deterrent effect by empowering the authority to apply for a search warrant and to enter premises for inspection. And then another part will be on the transitional arrangements. Part 3 is about the subsidiary legislation, some consequential amendments to the regulations on appeal, and also another part of the subsidiary legislation is to be amended, and that's about the fees and charges for a license. And then there are other consequential amendments to follow. If these are approved and the bill is passed, the Secretary for Home Affairs will, through a Gazette notice, announce a commencement date, and the 12-month transitional period will start at the same time. We would like to start or to continue with the cross examination starting from 12I. My team and I myself will continue to answer members' questions and address members' concerns. Members, you have received the government's papers setting out the administration's response to past issues. Do you have any comments? If you don't have any comment, I'll have one myself. There were only 7 cases in 2018 for license application. 4 are still under processing, 2 approved, 4 not approved. So the License applications under processing, there are quite a few such applications under processing. And last year, 4 were rejected under the new amendment ordinance once it's passed. Is there any room for further improvement? Let me talk about general big picture, and then I'll ask my director to follow up on other issues. We have stringent requirements such as building safety and fire safety for such license. We do set ourselves a time limit in processing the applications. The most time-consuming part, as we understand it at this point, is to give time to the applicant to comply with our requirements. A lot would depend on the applicant's actions. Some can address our requirements very quickly. Some will take a long time, and yet still they cannot rectify things to comply, such as the width of the passage is not wide enough, and so on. So we give more advice to help the applicant, and we'll also engage professional people to expedite the process. I'll ask Ms. Wong, Deputy Director, to say something about the 4 cases. In 2018, we went to inspect the premises in accordance with our past practice, and then within 35 days, we sent out a list of requirements to the applicant. As the Undersecretary has indicated, very often the applicants, because such holiday guest houses are in remote areas, or they have not engaged professional people to help them. Although we set a deadline and state that their applications will be rejected if they can subsequently comply with the requirements. Although the deadline set, we'll still give time for them to make up. So we have always been flexible and pragmatic in dealing with such holiday guest houses to comply, and if possible to come up with an alternative plan so that our requirements can be met. So what would the future hold for these applicants? Would there be better arrangements? We have introduced some new requirements so that we have to consider whether there are certain restrictions in the DMC or land lease, and we have also introduced a local consultation process. So perhaps we may need a little bit more time in the future, but we are making improvements on other fronts. We have set out the requirements listed on the website to increase transparency, so that the applicant can know well in advance what are required of them if they want to submit an application. Well, you operate a guest house, either you buy the property or you rent the property. If the processing time is long, it's a big financial burden. And in the future, there will also be local consultation. I hope the time taken will be reasonable. And the applicant has to comply with fire safety and buildings safety requirements, and yet there's going to be an additional process. So I hope you would take into account views from stakeholders, and the time should be kept reasonable. I don't want you to lose sight of the need to make sure that the investors' burden is not too heavy. Chairman, after introducing local consultation, we would still adhere to the present code of practice, and that is we would give out a list of requirements within 35 days. We would do our very best to try to shorten the processing time. All right, if there's no further question, we'll continue with the cross-by-cross examination. There are papers issued from the government, and also some other papers prepared by our secretariat, as well as documents issued by our assistant legal advisor. Members, please refer to those documents yourself. I won't read out the paper numbers one by one. Let's continue. We'll start with Division 4. We covered 12I last time. And that is if the license period exceeds 36 months, the license holder must submit a statement by an authorized person. Now let's proceed to Division 4. There's 12J to 12M. 4 major license requirements. 1. No use restriction requirement. In respect of a land lease or deed of mutual covenant, restrictive clauses in DMC, we need the applicant to submit such information. And then the suitability requirement, which is a current requirement, and additionally there's a fit and proper requirement. And then fourthly, we have the operation requirement. So this is about Division 4. Let's look at 12J, no use restriction requirement.
主要就係涉及到講明咧，我哋呢個政策嘅原意咧，落實我哋嘅政策原。
This is to implement our policy intention, and that is if the authority is satisfied that the premises are free from a use restriction. We are talking about Division 3, Part 3, and that is no prohibition again on the use as a hotel or restrictive use to the effect that it's only for the residential, private residential dwellings. And if there's no such restriction on uses in the land lease and the DMC, the authority can then proceed to consider the application. If not, the application will have to be rejected. Legal advisor regarding 12J. I want the government to clarify something here. If in the land lease or the DMC there's no such use restriction or ambiguity about the permitted use, if there's ambiguity, what can be what will you do? Can you refer to 12O, and that is in accordance with the views of legal practitioner? You refer to the views of the professional people.
12O 嘅條文咧。
We have introduced the new section 12O, which stipulates that the authority can request for documents to be provided by the applicant, including a certificate issued by a legal practitioner. For a land lease or DMC, if there are restrictive covenants, we would refer to the written legal advice by a legal practitioner. And like we said in our written response, if there are opposite views, when we consulted district consultation, if certain affected parties submitted opposite views, the authority can further consult the relevant policy bureaus or departments. If the government's land leases are involved, we would consult the lands department. On the restrictive covenants, if the premises cannot be used as lodging, guest house, etc., according to the DMC or land lease, would they be considered restrictions under the restrictive provisions? Ms. Wong. As for the interpretation of the restrictive provisions under the bill, and they refer to provisions with binding power. If they carry the same effect, for example, for use as accommodation, lodging, hostel, etc., they would be seen as restrictive provisions. If the scope is wider, for example, if commercial uses are allowed, you would accept an application from such building for guest house use. If there are no prohibitions against commercial use, so for commercial residential buildings, they would not be seen as carrying restrictive provisions. With the new ordinance in place, 200 guest houses would not be able to have their licenses renewed. So, do they fall under the category of prohibited industries or operations? Under the DMC, certain uses are disallowed, and our assessment is that these are equivalent to restrictive provisions. So beyond these 200 odd guest houses, from the operator's point of view, they might feel that they are not prohibited, and as such they would lodge applications. So would the renewal arrangements of the existing guest house operators be affected? For existing licenses, there would be a transitional arrangement. After the new ordinance is in force, for a renewal not exceeding 12 months, guest houses would not have to fulfill the restrictive provisions. Otherwise, the applicant would be needed to provide a document given by a legal practitioner, and if a contravention is deemed, applicants can make submissions under our mechanism of district consultation, and at that time the authority would consider views from both sides, and if there are ambiguities, we would consult the relevant departments or policy bureau. If anyone raises an objection against submitting a certificate or written document, are such documents submitted by the applicant applying for renewal or submitted by the complainant? First of all, the party making the application must produce the documents, and under the new Section 12.0, the authority would ask for such documentation. And stakeholders include other owners in the same building. They can seek legal advice on this issue, and the authority will then look at all relevant documents and seek further clarification or direction from the relevant departments if needed. Any questions? If not, let's continue. Section 12K, the suitability requirement. This is same as the existing Section 8 brackets 3. The existing premises must fulfill with the Buildings Ordinance and Fire Safety Ordinance, and the operation must be conducted under supervision from the licensee. This is an existing requirement. 12L, license requirement, fit and proper requirement. This is a new requirement. When the authority vets an application, they can consider whether the applicant is a fit and proper person by considering whether that person has been convicted of an offense under the Hotel and Guesthouse Accommodation Ordinance, or whether the person has been imprisoned for more than 3 months, or whether the applicant is an undischarged bankrupt. In such cases, the authority can refuse to issue a license. For the new Section 12L2A, when considering whether a person is a fit and proper person, the authority will consider whether the person has been convicted of an offense under the ordinance, and also whether that person has been convicted of an offense in Hong Kong or elsewhere. So that such offense must involve fraud, corruption, etc. And there are similar provisions, for example, the Dutiable Commodities Ordinance, Property Management Ordinance, etc. I hope the administration can explain whether the criminal elements include the items I cited above. There is no express provision on the type of offenses, but we would issue administrative guidelines to stipulate our considerations, and we might then refer to the relevant laws. The offenses must involve dishonesty, corruption, fraudulence, etc. Legal advisor, in considering whether a person is fit and proper, we would consider whether there are debts restructuring deals or debts repayment arrangements, and whether the relevant person or whether the manager involves another entity, for example, an entity that manages other hotels or guest houses, and whether a license has been revoked before. Would the authority consider these factors in deciding whether a person is fit and proper? In the future administrative guidelines, we will consider clarifying the issue. Legal advisor, any follow-up question? As I understand, administrative guidelines they are not legally binding. So would the administration consider providing for the express provisions under the bill. Ms. Wong? There were precedents in using or issuing administrative guidelines. The policy objective might be different from the intent. That's why we feel that issuing administrative guidelines might be more appropriate. Ms. Wong? Would it be too simple to resort to administrative guidelines? How about subsidiary legislation? Chairman, we hope to maintain some flexibility, but meanwhile the information would be made open and transparent. We made reference to other pieces of law. The treatment towards the fit and proper requirement are different. So there are precedents in introducing such approach. And one example is the Securities and Futures Ordinance. We have to stipulate the key considerations. As for other considerations, there would be transparency if we adopt administrative guidelines. Will the government provide a written answer? Like the administration said, if administrative guidelines are issued under other ordinances, please provide a copy for reference. Ms. Elvin Young. We will offer written responses afterwards. At the second reading, the Secretary can explain in detail our justification or practice. Ms. Elvin Young, on the administrative guidelines for 12L brackets 2 brackets A, B, and C. So these are the elements to be considered by the administration, but administrative guidelines are beyond these elements. If an applicant in the future satisfies these three elements, but he fails to satisfy the administrative guidelines, then how would you treat the administrative guidelines? If anyone feels aggrieved or feels that they are treated unfairly, subject to a JR. So what is the basis for promulgating and amending the administrative guidelines? If anyone feels aggrieved or dissatisfied, we have an appeals mechanism. An independent committee can consider their views. DOJ, please. Mrs. Z. Thank you very much. As for the power of the authority, it primarily comes from the new 12L brackets 1. This gives discretion to the authority in considering whether the relevant person satisfies the fit and proper requirement. 12L brackets 2 simply lists out the factors to be considered by the authority in considering whether a person is a fit and proper person. This is not an exhaustive list. In other words, these are not the only factors to be considered. So the authority has discretion under 12L brackets 1 in considering whether a person is fit and proper. And because of 12L brackets 1, the authority can issue administrative guidelines so that the public would better understand what the authority would consider under 12L brackets 1. If the public feels aggrieved, can a JR be filed? This is possible according to administrative laws in the discharge of any administrative power unless there are any prohibitions to the rights to a JR can be raised.
明白施先生嘅講。
I know what Mr. C is saying, and I also know the normal practice. Maybe this is not a familiar subject to me. If an administrative power is exercised through discretion, I think this is the usual way of drafting in bracket 1, and bracket 2 are just some examples, factors that he will have to consider, but it's not limited to those factors. Is this the usual practice in drafting? Mr. C, thank you for your questions. I think Mr. Young's understanding is correct. This is not a so-called general practice. But if we want to empower the authority with a discretionary power, 12A1 will suffice. But the Bureau thinks that we should also set out factors that the authority must consider, the 3 factors in bracket 2. The usual practice is that we just have 12L bracket 1 if we want to give a discretionary power to the authority. And the power to issue administrative guidelines is also based on 12L1. What about restaurant license and liquor license? Do we have a similar arrangement? Well, that I don't have the details with me. I need to check because this is about the licensing of different matters. That is restaurants and liquor license. Well, we have made reference to other laws in drafting this bill. For example, in the liquor license legislation, there are certain factors that must be considered in processing an application. We know that there is also a set of administrative guidelines issued for the purpose of liquor licensing. And as I've said, we have made reference to the Securities and Futures Ordinance. Our legal advisor can provide supplementary information in writing, setting out which other laws have been referred to. We cannot come up with an exhaustive list that will not be flexible because of changing social circumstances over time. We should not do that. In the future, when we want to supplement the factors to be considered, this will be done through the administrative guidelines. All right, further questions? If not, then let's have the written supplementary information after the meeting from the government. Well, this is just transferring the existing Section 10 to this particular clause, 12M. So, Division 5, other functions of authority. Specifically, 12N authorizes the authority to consider views of those affected by the license. So this is about the introduction of local consultation. So this clause authorizes the authority in processing applications may consider views of persons affected by the application. So this is an additional power. Yes. is it an additional power or not? It's an additional power. The current ordinance doesn't authorize the holding of local consultation. Legal advisor? Can the administration tell us more about the advisory panel's composition? Would there be any eligibility criteria for appointment? Well, our preliminary thinking is that the advisory panel will comprise people from different professions and different experiences, including surveying, legal backgrounds, and local personality. Well, are you talking about district councillors when you say district personality? This will be done through administrative guidelines as well. The details of the composition will be such that we need to have professional people and local representatives. We would go for representative, local personalities. Would we consider appointing district councillors? We leave such matters to the district guidelines. Of course, they would be among those considered for appointment. Further questions? Next. 12. Authorities' power to request documents, information, and legal advice. We have mentioned this briefly a moment ago. Wait, please. We have something from our legal advisor. On sub 12N, bracket 6, affected people to be consulted. Would you clarify the point about surrounding area? How big are we talking about in terms of the surrounding area? Maybe I can say something about the bracket 6 in particular. If the premises are in the same building of those people, affected people, let's say a guest house would occupy certain stories or units in a building. It's not a standalone hotel in one building. Then we would consult the owners or occupiers of other units. And if it's a standalone building, we would consider affected people in the surrounding area. As regards what would exactly be covered, again, this will be set out in our administrative guidelines to define who are the affected person. We will make reference to the Town Planning Board when they consider an application. They will consider the views of property owners within 100 feet of the relevant location.
㗎啦，咁呢個係其中一個我哋會考慮，但係因應呢方面呢，我哋細節上面會係用一個行政。
The details will also again be set out in administrative guidelines. 100 feet. You mean that this is the radius of 100 feet? Yes, 100 feet. If it's about traffic implications, what about the views of other stakeholders? Are you going to accept their views, or consider their views? Well, that's just for reference. We would maintain some flexibility, for example, in considering AGC or the amusement game center applications. We also provide for some flexibility. We want to give the applications a general idea how much will be covered. So administratively, we say that it is about 100 feet from the application location. but the authority can have regard to the special circumstances of the location and consider some flexibility.
而 O 條呢，就監督要求文件資料及
12O, authority's power to request documents, information, and legal advice. We've mentioned this briefly a moment ago. This is to tie with the no use restriction requirement. The authority can ask the applicant to submit a written legal advice given by legal practitioners to support the application. P is mainly a copy of the existing ordinance. Duty of authority to give notices of certain intentions or decisions. This is already in the current ordinance. If the authority intends to reject an application and so on and so forth, he has to inform the applicant and other relevant people. Any time limit here? If the authority intends to cancel or revoke or reject an application before the power is exercised. Let's say 12P bracket 1, if the authority wants to invoke power in bracket 2, that is refuse to renew a license or to cancel or suspend a license or to amend certain licensing conditions, and before such powers are exercised, the applicant, the licensee rather, must be informed. Let's say suddenly you want to do this, what about providing for a notice period? The applicant or the licensee can make representations when informed of the decision. If there's a representation or there's an appeal lodged, the decision will be held in abeyance in the meantime. So that's all for this particular part. We can now move on to a new part, Part 5A, Appeals. 0039 5A is in respect of appeals against decision of authority. This is an update of the existing appeal mechanism. Most of the provisions are already in the current ordinance. However, in the future, we believe the appeal board would have to handle more appeals. So we are going to set up an appeal board panel. At present, we've just got only one chairman. In the future, there will members who are qualified for appointment as a district judge to be chairman of the appeal board. Apart from stakeholders of guest house, hotels and guest house applicants, would other people's appeal also be handled by the appeal board? Well, yes. Anyone who is aggrieved by the decision of the authority can lodge appeal to this appeal board.
If there is opposition from the district personnel and if eventually an authority grants a license, so district personnel who feel aggrieved can launch an appeal under the system. Currently, there's only one chairman dealing with one appeal at a time, and in the future there would be two chairmen. In other words, two appeals can be handled at the same time. So in the past, was there a serious backlog of cases? In the past, we only dealt with a single-digit number of cases every year, so a single chairman would be sufficient, and there is no backlog. But under the new licensing regime, we will provide 2 chairmen for the 2 appeals board, and hopefully we can speed up the processing of the appeals. According to the paper, at least 2 individuals will be appointed. Can more be appointed? My concern is that you might receive complaints or appeals on license renewal applications. The district stakeholders might be unhappy. As for the guest house operators, this might affect the time they have for an application. So for a typical appeal, how long would the entire process last? I know that at a lot of public bodies, the number of appeals is very high and there's a very long queue. So have you encountered such issues? In the future, we will look at the land leases and DMCs, and we must conduct district consultation. So we expect a higher workload and more cases in future. According to the bill, under Clause 17b, brackets 2, brackets A, the panel is to consist of at least 2 individuals appointed by the Chief Executive, each of whom must be an individual qualified for appointment as a district judge. So the minimum number of members would be 2 plus 16, but there can be more. The CE has the power to appoint more members if needed. As for the time needed to process appeals in the future, we would certainly monitor the situation, and we have a number of service pledges under our licensing regime, and if necessary, we can introduce further service standards to satisfy the needs of the public and applicants. For the appeal board panel, apart from the chairman, how many members are there? At least 2. Only a single chairman and 2 members are what is needed to deal with an appeal. This is a very important issue because you are going to see a lot of appeals. In terms of the service pledge, where can that be found? Is it within the administrative guidelines? In Clause 17d, after the convener receives a notice of appeal, an appeal board must be formed within 21 days. So as soon as we receive a notice of appeal, the appeal board consisting of 1 chairman and 2 members must be formed, and the chairman of the appeal board must issue a notice of inquiry as soon as possible. So there are provisions on these. And for the subsequent procedures, we would stipulate them via the administrative guidelines. So would the application of a license be affected by the appeal? As for guest houses seeking renewal of licenses, would they be affected by the process of appeal? For guest houses that have already been granted a license by the authority, their application would not be affected. For those seeking renewal, if the renewal is rejected and that the affected party launches an appeal within 28 days after the authority makes their decision, there would be a stay in such decision. What if a complaint has been received ahead of license renewal or during license renewal? Since an appeal is underway, would the renewal application be affected? If the complaint does not involve suspension of license, then the license would still be enforced. Let's say if I prepare for a renewal half a year ahead of time, some residents from the building might provide grounds for an appeal, such as noise. And after you make an application, a board will be formed within 21 days, and as such, the period for license renewal might have lapsed. So are you going to allow a renewal first, or are you going to provide a provisional renewal procedure? As we said, an appeal must be lodged by the aggrieved party within 28 days of the decision by the authority. Normally, our licenses last 1 to 7 years. If a license is about to expire and if any complaints are received in the meantime, they would be dealt with by the authority. Unless the authority makes a decision that involves revocation or suspension of license or the additional of new licensing conditions, the authority would not have any decision to make. So for administrative decisions, they would not affect the appeal and they do not form the basis of an appeal. So the authority must have made a decision under the ordinance, for example, revocation of license, suspension of license, or addition of licensing requirements. Only if such decisions are made can the appeals mechanism be invoked. All right, so those applications will not be affected. All right. As for the remaining provisions, they were made with reference to the current provisions. Legal advisor. The appeal board panel will not consist of less than 16 other individuals appointed by the chief executive. Can the administration explain who these other individuals are? Ms. Wang. Currently, the individuals appointed by the CE include professionals and district personnel. That is the current arrangement. So in the future, we will also consider such individuals as members of the appeal board panel. Please continue. So the remainder of this part about the appeal board. So the provisions leading up to 17J are only updates of the existing provisions. As for the sum awarded in respect of appeal, the appeal board panel has the power to decide whether a renewal is granted. Do they also have the right to award sums? For Clause 17F, this is the existing Section 15 brackets 9 of the Ordinance. The appeal board panel can award a sum, which is the cost sum. So if the appeal is upheld, the government must repay those costs. So this refers to cost sums. So we can now move on to Part 6, Supervision of Hotel or Guest House.
係呢一個係第6部呢，就係、
This is an update of the current Part 6 and will be substituted by 18 brackets 1. And the current provision is inspection of guest house to be substituted by inspection of licensed premises, and this stipulates that the authority and its enforcement officers can make inspections without a warrant to ensure that the operating requirements are complied with. So under the current ordinance, the officers can enter a guest house without a warrant. Yes. It depends on whether the party involved is cooperative. If it is not a licensed guest house, and if our enforcement officers want to conduct inspections, it would depend on whether the relevant party is cooperative. So for the new 18A, it stipulates that a warrant can be applied for from a magistrate, and the magistrate may issue a warrant authorizing an officer to enter and search any premises. So this is the new Section 18A. So under the new Section 18A, the officers can enter and search any premises when appropriate. So in the future, circumstantial evidence can be cited. For instance, if advertising materials are secured, or if there are any complaints over an unlicensed guest house, I can enter and search the premises. So there are no such current provisions, but in the future, the exercise would be easier because with circumstantial evidence, you can enter and search a premises without a warrant. So does this provide greater convenience to enforcement officers in the future? Yes. In the past, since our officers can enter and search without a warrant, but a reasonable time frame is stipulated by the ordinance. Very often the operator is not cooperative, and I have looked at a number of enforcement operations, and we found that very often the officers would not answer the bell. However, under the law, we do not have the power to forcibly enter the premises. In the future, after applying for a warrant, we can enter and search anytime, and if the party is uncooperative, we can exercise appropriate force.
啲環境嘅證供咧，
And then we can collect circumstantial evidence to assist our enforcement. It says without a warrant, you can do this. You can forcibly enter the premises. Are there any guidelines or the code of conduct to regulate the officers conducting the inspection? So as to address the question of abuse of power, rest assured that this is not going to happen. We have a very stringent internal guidelines. We have been doing this for years. First of all, we cannot go to residential dwellings without good cause. We have to make sure, or we have to get hold of reliable information or intelligence that this is an unlicensed guest house before we take such action. Mr. C, you want to supplement? Thank you, Chairman. Yes, I just want to supplement a point concerning this power to search without warrant. For Section 18 in the current ordinance, the search without a warrant has to be conducted on a licensed guest house. If it's an unlicensed one, then under Section 18A, a warrant is required. So is that the official interpretation? Then that's better. Mr. Charles Moore, can you tell us under what circumstances there's no need to have a warrant, and under what other circumstances a warrant is needed? You talk about the well-established practice, but in the past you didn't have any power to enter by force, and in the future with this bill passed, you are given the power. So at least you should have some guidelines so that we all know who in your department will be doing this, because we're talking about risk here, not just for the affected operator, but for the officers. We need clear guidelines to protect them. And the Secretary, I agree with Mr. Moore. We would come up with very clear guidelines that this is a new power. We'll give guidelines to the enforcement officer so that they can conduct their operations. As for the drafting point, I'll defer to the law draftsman. Mr. C, please look at C1553, the updated Section 18. Section 18 applies to licensed hotels and guest houses. That is to say, the entry without warrant is only in respect of licensed premises. As for C1557, we can see the newly added Section 18, capital 8. It covers all premises, but there must be reasonable grounds, and also when the conditions of the license is contravened, and the application for warrant must be made to a magistrate. So it's Section 18 or Section 18A. So if it's a licensed guest house and you want to make a surprise inspection, you don't need a warrant because you suspect there are certain contraventions. But if it's my home and you want to inspect my home, you need a warrant from a magistrate, right? Perhaps the department can provide a written reply to this question. I hope we can clarify this. Is that the enforcement an offence authorized by warrant issued under the sections may enter the premises at the time specified in the warrant, or if no time is specified, at any time. Maybe a reasonable time should be specified, otherwise there may be other problems. Ms. Wong, we believe the current provisions have provided suitable safeguards. For example, under bracket 5, bracket A, the court in issuing a warrant for the search may specify a time. If there's no time specified, then we can enter at any time. The enforcement officer will certainly take into account the relevant circumstances and consider whether it's suitable to enter. We know that certain guest houses are in operation 24 hours around the clock, and in the morning maybe there's no one inside the guest house, so we cannot enter. So we would make sure that will enter at a reasonable time. We believe that there's no need to specify what is meant by reasonable time. If you're a licensed guest house, then under what circumstances would you need to conduct an inspection of this kind? The guest house is already licensed. Well, the authority would conduct annual inspections to ensure that the fire safety requirements, etc., are complied with. And in view of the report of the audit commission suggesting that we need to conduct inspections to ensure that the licensee always comply with the licensing conditions. So this will be done on a random basis. We would conduct a random inspection of such guest houses. The purpose is to ensure that all the licensing conditions in regard to fire safety, etc., are complied with. All right. Further questions? No. We now move on. 6A, Part 6A, orders made by court or magistrate. We've introduced a new Part 6A. We have a 20 to 20J, clause 20A to 20J. This is about closure order, a new subject, a new power. If there is a conviction under the ordinance and within 16 months there's another relevant conviction, we can apply to the court for a closure order. So these are the new provisions related to this new regime. On Section 20, remedial order. This is an existing provision to be updated under the bill. All right. (0057) closure order. Offense is repeated within 16 months, then an application can be made to the court for a closure order. How long would that order last? 6 months. 0059. The closure order will specify that from the day specified in the closure order, the premises will be closed for 6 months. So if the court can direct that the premises are to be closed for 6 months. 6 months is the maximum? It's for 6 months.
亦都係希望可以提高嗰個阻嚇力嘅。
Want to ensure a deterrent effect.
嘅條文呢，涉及到撤銷封閉令啊、暫緩封閉令啊，或者更改封。
And then there are other provisions on how to revise or suspend the closure order. All these are procedural issues. This is issued by a court, so the appeal can only be lodged to an upper court. In 20C 0061, the affected person can apply for the rescission of the closure order. The interested party, mainly in 20C, we are talking about bona fide purchasers. If they comply with these provisions, can apply for a rescission of the closure order. Bona fide purchasers. You mean another owner comes in, a new purchaser? Yes. For example, for the first conviction, an entry will be made to the land registry over the premises. And if the authority prosecutes for the second time for a related offense, an entry will also be made to the land's registry. There's a small window in between, so the bona fide purchaser may have exercised due diligence in respect of title search, and he doesn't know that there is a second conviction, and he has already purchased the property when the closure order, before the closure order is issued. Then if he is a bona fide purchaser, he can apply to the court to rescind the closure order. This is to provide an innocent third-party bona fide purchaser. Mr. Alvin Young, I want to say something about Clause 20A, closure order, bracket 1, bracket A, present conviction. Can the DOJ or the Bureau clarify this? I don't want to second guess the meaning. May I be assisted about the precise meaning of present conviction? Mr. C. Lord Jobson? Thank you, Mr. Young. In 20 capital A, bracket 1, bracket A, a present conviction is respect of a specified offense. And we will look at 20A, capital A, bracket 9. We can see what specified offense means, an offense under section 5 or 5 capital A. Why do we have to set out in 20 capital A that this is about present conviction? The closure order is based on 2 convictions. So 20A is about the present conviction, and there's a previous conviction before the present conviction, and that's why the closure order is issued. Bracket B says the authority applies in writing for the order. So there's no hearing required by the court. The authority can apply in writing. Or would the court still hold a hearing for the application? Mr. C? Whether there's a hearing or not,
其實應該咁講，因為咧
For the closure under section 28 brackets 1. A person is convicted for a second offense and if needed, the authority would apply for a closure order. What Mr. Z meant was the usual circumstances or the normal circumstances. If there is a criminal conviction, the prosecution would apply for a seizure order, etc. But if the authority makes an application afterwards instead of an immediate application for a closure order, can they make such application afterwards? Mr. Z, there are no express provisions against making an application afterwards. In other words, if such application is needed, can a written application be made, or would an inquiry be needed? The bill does not stipulate whether court proceedings are necessary. If the prosecution makes an application, there would not be any issue because the aggrieved party can make a case. But if an application is made afterwards, would a copy of the order be issued to the aggrieved party? Ms. Wang, if a court issues a closure order, the authority would register the closure order with the Lands Registry. She was referring to what happens afterwards. I'm referring to the rights during the proceedings. Ms. Wang, Mr. Young was referring to the actual course of proceedings. In other words, when considering whether a closure order would be granted, they can offer a written response after the meeting. But I think this is a key issue. The rights of aggrieved parties and how they should be dealt with. So this is a procedural question. Mr. Paul Chair, I don't know whether this is the answer, but under Section 20, capital A, brackets 2, some conditions must be fulfilled before an application is allowed afterwards. And according to bracket C, a notice must be published within 14 days after the date of the previous conviction. So in other words, after a conviction, a notice must be published or posted within 14 days, and the operator cannot say that they do not know about the decision. I think this has provided sufficient safeguards. Ms. Wang. Subsection 3 is about the previous conviction. When you look at page 0058, brackets 2b, on a previous conviction, it lays out the circumstances under which a court would grant a closure order. There must be a previous conviction at the same premises, and the authority has acted according to subsection 3. So in other words, if there's a previous conviction within 14 days of the conviction, the authority must carry out the procedures mentioned by Mr. Porcher. Apart from publishing a notice on newspaper, the owner and tenant must be informed. And at page 0059, item 4, there's a reminder that if an offense is committed again within 16 months, a closure order can be effected. So in other words, the authority must carry out the above acts to warn the operator that if they are convicted again within 14 days, a closure order can be made. I'd like to skip to page 0070, 20J. The notice must be registered at the Lands Registry, and under 20J brackets 2, if a court of magistrate makes a closure order, suspension order, variation order, or revival order, the court must submit the order to the authority as soon as possible, and the authority must, as soon as reasonably practicable after receiving the copy, arrange for the copy to be registered in the Land Registry. So in other words, the authority would register the notice in the Land Registry. So for the bona fide purchaser of such premises, if they make the purchase before the authority conducts the above acts, the purchaser can apply for a rescission of the closure order under Section 20C. In other words, the court must inform the authority as soon as possible, and the authority must register the copy as soon as possible in the Land Registry. I think if we consider the questions by myself and Mr. Young together, you would register the notice and notify the bona fide purchasers. So for a number of CG orders by the customs, etc., very often they would apply for an order from the judges as immediately, and there might be contests. So just like driving offenses, the convicted parties would have to fend for themselves. There is a lack of due process or the opportunity to make an immediate contest. We can consider whether administrative arrangements can be put in place in the meantime so that the relevant parties would know the processes coming. And that way appropriate acts would be taken out at appropriate times. We would provide a written response. I have a technical question to make. Why is the threshold at 16 months and not less? Why is the notice period set at 6 months? Why can't it be longer and shorter depending on the number of offenses already committed? Why is the system so rigid? When we discussed the policy side of the bill, we mentioned this. The closure order has made reference to vice establishments under the Crimes Ordinance, and for those offenses, if there's a second offense committed within 16 months, a closure order would be applied to the court. So the design of this section is based on the vice establishments. So we would provide a written response. What about the discretion of the court? Are we on the same page? As we said, a closure order would be applied after 6 months. Why is this so rigid? We have drawn reference to the system of closure orders for vice establishments. Vice establishments are very different from guest houses. You cannot mix the two. You cannot just blindly copy another law. For the past, for example, for the Travel Industry Authority Bill, so have you determined that 16 months is an appropriate threshold based on the vice establishments? We must strike a balance. The newly introduced closure order must achieve a deterrent effect. So I think a 6-month closure order is appropriate. It is an appropriate length. We consulted in-depth consultation, and the Home Affairs Department attended before LegCo to discuss the issue, and there is consensus that 6 months is appropriate. I will follow up after Mr. Young asks his question. 5 minutes each. Mr. Young, thank you. I'd like to thank Mr. Chair for his question. I'd like to ask about the due process. Under Section 28 remedial order, or the closure order, an application can be made in writing, but on page 006420E, the affected person can apply for suspension of closure order, and in brackets 3, we saw that if the court accepts the application, there would be a hearing. So if the affected person raises an objection, they would only be heard at that junction by the judge. According to Section 28, is this akin to the application of a warrant from the police? Normally, the police would make an application for a warrant from the court, and there would not be any proceeding or hearing. Is this the government's intention? Apart from the suspension of order on page 0062, there would be another date of hearing for the revocation. Generally, the court can deal with it when a judgment is laid. If a hearing is needed, there is no prohibition against dealing with a hearing. For the new Section 20A, we made reference to the Crimes Ordinance, which carries similar provisions, as well as the fire safety abatement of fire hazard notice. So we hope that the court can deal with the issue immediately to speed up the process, but we would not rule out the need for a hearing if deemed necessary. For revocation or suspension of order, a separate hearing would be arranged by the court. you can imagine that a suspension application is needed and there is a time frame for that. If an application is made for the sake of fairness, the authority would be informed as one of the parties of hearing and as a respondent. And the relevant provisions have made reference to relevant current laws.
其實都確認咗咧。
I think the Deputy Secretary has confirmed this. In respect of rescission or suspension, the authority's right to be informed is protected, but on the first application under Section 28 for a closure order, unless it's done immediately after conviction, the closure order is considered right after conviction. Then the right to be informed is not protected. The affected person's right to be informed is not protected. I would like to have a provision in the bill to safeguard the right of the affected person to be informed. Can this be done? Under Secretary, I have promised already to look at the entire workflow to see how we can protect the interests of the affected person. There are other Mr. Alvin Young's point is just one of the issues to be considered. We'll look at other issues. Mr. Paul Chair. Well, according to the Undersecretary, you have already conducted a consultation, but can you briefly tell us why the time frame is set for 16 months as well as 6 months for the order? Can you briefly explain so that I can understand why? Is it based on the past practice or the past experience of enforcement against a guest house serving as vice establishment? And also there's a technical point. 20 capital C, an interested party who is a bona fide purchaser. 20 capital C bracket 2, someone becomes purchaser or mortgagee, and that is a purchase takes place after the order is issued, or the mortgage is taken out after the order. But so does it mean that it doesn't apply to anyone who purchase or takes out the mortgage before the order? And also for you use the present tense for the purchaser or mortgagee. The person, if the person becomes in present tense a purchaser or mortgage, can the legal advisor or the bureau clarify the time sequence of such events? As I've said, we believe that 6 months represent a reasonable balance. If it's very short, and we are mindful that a lot of procedure will be involved, and we have to go to court. And if the closure period is so limited, it's not worth the while. But if it's for too long, we're talking about real property, which is valuable, and I believe this is. This is considered right balance, and we have make reference to the same arrangement in respect of vice establishment, and there was prior consultation back some time ago. Ms. Wong, 20C, bracket 2. If a person becomes a purchaser, mortgager or chargee in good faith for valuable consideration of an interest. But this is in a conditional phrase. We were talking about something that happens after the first conviction, the previous conviction, the authority already enters something. There's an entry in the lands registry, and then upon the second conviction, that there's also the need to enter another charge in the lands registry. But before that happens, there's a time gap. So when someone does a title search in the lands registry, he will only know about the first conviction. And if it's a bona fide purchaser, he can then invoke this particular provision in applying to the court for a rescission of the order. As for another provision which relates to the time period after the closure order has been issued. So at the point of the issue of the closure order, he's already an affected person. So it doesn't have to be in the future tense. For 20E bracket 5, the suspension order can be for 2 years. Why is it that a suspension order is as long as 2 years, but the closure order is just for 6 months? Again, we have made reference to similar legislation, including Crimes Ordinance and the abatement of fire hazard regulations. I haven't got the chance to look into these other laws on why the suspension order would last for 2 years. Why is it 2 years? Even for closure, it's just for 6 months. You have make reference to other laws. Have you overdone this? We think that the existing provisions provide good reference. We understand that these other laws have been implemented very satisfactorily. Well, this is just like a broken record. Why can't you look into the reasons? The closure is for 6 months, while a suspension order will last for 2 years. Don't tell us that you have make reference to other laws. Otherwise, there will be no need to draft new laws afresh. We'll just make reference to previous laws. Well, this is not a question of overdoing it. The closure order is for 6 months, but the for 20E5, the closure order will be suspended for not more than 2 years. You cannot say that the suspension period should not be more than 6 months. For example, the closure order is for 6 months from the 1st of June this year. But if this is suspended, then you don't have to be closed for starting from the 1st of June this year. It will be sometime later, within 2 years. So there's no question of that incompatibility between 6 months and 2 years. But as for whether it's 2 years, is for the Bureau to elaborate. I think for a suspended sentence, if it's a criminal convictions, then you don't have to go to jail if it's a suspended jail sentence. And now, are you saying that the premises will be closed for 6 months after the suspension period of 2 years? Or whether the closure order will be revived after suspension period? Well, we can look at the 20E bracket 8. And if a closure order is suspended and is not revived under section 20H, the order ceases to have effect at the end of the suspension period. In other words, if it's a suspended order and the authority doesn't apply for its revival, then the order ceases to have effect after the end of the suspension period. Mr. Chair.
晒所有呢啲條文嗰個前因後理，但係聽落去似乎都幾複雜下喎。你咁做法，即係每一個步驟都係有。
This seems very complicated, perhaps because I haven't gone through all the courses. Maybe it's just the usual practice of copying other laws. So there are many obstacles for the affected person. He is required to do many steps. Lawyers will be very happy because there's lots of job for them to do. Can you streamline the whole process? Under Secretary, I think the right balance is required here. We want to be fair and just, and we need to safeguard the rights of all affected parties. We believe this is a well-established and effective mechanism. During the suspension period, the occupier or the owner can continue to use the premises during the suspension period. This is the spirit of the suspension order. And if the closure order is to be implemented, then it will mean that is for 2 years. But under this period of this suspended order, the use can continue. But it's for different purpose, right? Of course. I think that there's no contradiction here. The question is whether we think the relevant period is reasonable or not. Let me go back and check against the arrangement for vice establishment. I'll try to check the precedent cases. Maybe the Undersecretary has said that it's the result of making reference to other laws. I don't know what you have been told. It seems that the closure order is very rigid. It's 6 months or nothing. I just don't feel comfortable about this. Let me do some homework and follow up the matter later. The Undersecretary has already promised to provide some thing in writing. Perhaps the next time you can follow up the matter when we receive the reply. Well, thank you for the questions. Although we unlicensed guest houses are not exactly vice establishment, but we understand that they can unlicensed apartment can pose a serious risk to life and property, like the cases of Continental Mansion. So that we need to deal with such cases very carefully. Well, don't always quote Continental Mansion. That's a very minor, serious case.
嘅並不是話我係忽視咗有關嘅需要監管有關無牌賓館嘅要求同埋需要。
We need to look at the importance of the matters and the need to properly enforce the law. I want to know the rationale. And don't just say that we copy what is provided for the vice establishment, and when asked for reason, you will say that we have consulted people. Well, it seems that just like the CSSA, the changes were mentioned in consultation, and afterwards that's it. You know how many members are here in disputes committee, and if this is just passed without further deliberation, then the new arrangement would be there and take effect. Although we know we need to pass the law quickly. it's just a joke. I just hope that this will not be done too quickly.
問題，再睇政府回應。
So after the administration response, we would follow up on the issue. Mr. Elvin Young, any follow-up question? If not, let's continue. Page 0072, Part 7. General and miscellaneous provisions. This updates the existing Part 7. On the existing Section 21, we would repeal offenses in relation to certificates of exemption, and the rest have remained unchanged. Section 21A at 0076, we have updated the existing Section 21A to clarify the time limit for prosecution of summary offenses. And under the bill, there is a time limit for indictment, so we have specified only the time limit for prosecution of summary offenses. For the new sections 21B and C, the clarification of liability of the relevant bodies. 0079 and enforcement, and new provisions have been added. We have introduced 21D, appointment of enforcement officer, and the authority may appoint any public officer to be an enforcement officer, and 21E, duty to produce evidence of authority. This is an update of the current section. For 21F, the authority may appoint in writing any public officer. So in a decoy operation, if a non-public officer is appointed to collect evidence, would this also apply? For non-civil service staff, even though they are not public officers, they can be appointed by the authority as enforcement officers. Deputy Chairman, the speaker is not coming through. Mr. Horace Chang, am I coming through? All right. On the written authorization, for some government departments, the SFC would authorize certain public offices via a letter, and a list of names might be authorized. So is this the approach you are going to adopt? Ms. Wong? Thank you very much. Similar arrangements are in place in the current submissions. In the current 18A, authorization of public offices is provided, and in the future, an authorization letter would be signed for every enforcement or public officer. Mr. Paul Chair, to follow up on what Mr. Chung said, and in Section 21D, there's an appointment of any public officer to be an enforcement officer. So what is the difference between this and Clause 21E? The scope of 21E is apparently wider. For 21 capital E, it is not about empowering a person. It provides safeguards for the relevant persons. If any person exercises a power under Section 18, 18A, 20, or 20B, documentary evidence of the appointment must be produced. In other words, for the appointment of enforcement officer, it is only carried in 21D, while 21E is about producing evidence of authority. So are only enforcement officers allowed to discharge powers under sections 18, 18A, 20, or 20B? No. When we look at Clause 21E, bracket C, it is about power exercised by a person authorized under Section 20, brackets B, brackets 5, brackets B, and as for a remedial order, in the discharge of the remedial order, the authority can appoint persons to carry out the remedial work. So the scope of 21E is beyond the appointment of enforcement officer under 21D. Anyone who exercises a power under sections 18, 18A, 20, or 20B would be governed. Thank you for the clarification. But apparently 21E is not just about producing evidence of authority. It might cover the identity of persons who are not enforcement officers and not public servants. As for the persons enforced or authorized to exercise powers under these four sections, it depends on the respective provisions of those sections. 21E is only about the production of evidence of authority by those officers. All right, let's continue. 21F, evidence by documents. This is an update of the current Section 21F, or the current sections 8, bracket 6, and bracket 7. If the authority has verified any document unless otherwise shows, such document is taken as given or issued by the authority and as so signed. Clause 21G, this is a new provision on immunity from civil liability. This is added on the recommendation of the DOJ to clarify the provision. We have added provisions on a warrant and closure order, and there are provisions to authorize public officers or plaintiffs to discharge their duties, and they would be immune from civil liability. So under Clause 21G, brackets 1, for persons who conduct acts in good faith, they would be immune. But according to 21G, the government is not immune from civil liability. So in other words, individuals would be immune, but if the government commits any wrongful acts, they can be sued. Mr. C, thank you very much. Mr. Chair's interpretation is generally correct. Usually we would immune certain persons from civil liability. As for affected persons, even though their civil liability is immune under subclause 1, but the liability of the government is not affected. So if the government is commits any wrongdoing, they would be held liable. This is only fair. So would this be a better approach in relevant laws? Yes, for the relatively new laws, we would often see if other parties are held liable, and in many cases this is the government. So it is about time. So for the next part, part 8, we will begin with a clause by clause next meeting. Any other business? No. I will work with the Secretariat and government on the date of the next meeting, and members will be informed. Thank you. We have no any other business.